Hi, everyone. Thanks for joining today. My name is Jill Hasselmann. I'm the Chief Growth Officer at HR for Health. And today we're going to talk about a topic that, let's be honest, most of you really hate dealing with because it's one of the biggest areas of legal risk in the practice. It also is a very emotional topic, an emotional situation when we're dealing with this, and that is terminating employees. So our goal for you today is simple. I really want to help you get to a place where we're helping to reduce your risk, giving you some practical kind of real world steps to implement, and then make sure, above all, you don't accidentally create a lawsuit while trying to solve a people problem. And why this conversation matters to us, at HR for Health, we work specifically with healthcare practices, with dentists, optometrists, vet, any, private practice, small business that's operating, and we see where things go sideways every single day. And I think it's important to start with addressing the elephant in the room that's usually in the room when I have conversations about terminations or just general unhappiness with a team member. I frequently hear, but Jill, I am in an at-will state. And that's true. Every state, with the exception of Montana, is an at-will state. But I consistently hear this as kind of an assumed protection. We tell ourselves, I'm at will, so I can fire anyone at any time for no reason at all. And again, this is true about being in an at-will state, but there is a reason why I call it the at-will conspiracy. It's because there are so many subtle mistakes that come into termination situations that really create risk. And that risk cannot always be solved with leaning on being at will. And it's rarely one big mistake. It's usually these small things that add up, like missing documentation, outdated policies. Think about your employee handbook, expectations you've given to the team. A lot of it comes down to inconsistent processes or inconsistency with how you're treating different team members. And we'll talk about that in a little bit. Payroll and timekeeping gaps are a big part of this, or just simply termination decisions are made without enough support. So without really talking with an HR expert to help you make sure you're thinking through all of the things that could go wrong or could go right, and maybe just acting out of emotion with these things. And the reality is these are the small gaps that attorneys are looking for. It's exactly what they're kind of waiting for when they take on these cases. And so today is really about tightening those gaps before they become really expensive problems. And so here's what we're going to cover. We're going to go through the different types of employee separations, because this matters depending on if they quit versus if you fire them, that what documentation you have to give them. So the nuances of that are important. And then really the meat of it are the most common and costly mistakes that we see that we really want to help you to avoid. We're going to look at then what should you be doing instead. And we will have, if we have time, we'll go through Q&A. So please feel free to submit your questions as we're going through this. If we don't have time to get to the questions at the end, or maybe your question is like very nuanced for your particular situation, you might be on this webinar like ready to fire somebody. So we'll take that offline and connect with you individually. And again, this is meant to be practical, not like theoretical. So this is what you can really apply back to your practice like immediately to get these things in order. So step one to not getting sued is actually understanding what type of separation you're dealing with, because each one carries different nuances and thus like some different risks. So the first one is termination. So very simply put, termination is when you decide to end employment with an employee. So they don't really have a say in it. You're going to them and saying, you're no longer welcome here to work in this practice. And then a resignation is when the employee decides to leave. And this distinction really does matter, especially when it comes to unemployment, documentation, that legal exposure. And we're going to talk about some more nuances between these, because I understand there can sometimes be some gray area, like if an employee puts their resignation in and then you want them to leave sooner. Like, we'll talk about those intricacies, but again, just keeping in mind, these two are really kind of the fork in the road that you're most commonly going to be experiencing or, deciding between. Then we have layoffs. So these are actually business-driven separations. So it is similar to a termination, except this is because the business needs this versus a performance issue. So again, in the layoff, you're letting this employee go, and hopefully you can rehire them like when the business comes back from whatever is going on. So it's not something that the employee is necessarily doing wrong. It's just that you don't need them in that position anymore. And then if you needed to bring that position back into play, you would want to consider these employees before going and looking at a different pool of candidates. The reason for this is that you don't want it to look like the layoff was actually cloaked as a termination. So again, this is because you need to, but if you're going to open this position back up, you absolutely want to consider those people that you laid off and not make that mistake of saying, I laid you off, but then I hire somebody for that exact position a week later. So be careful about that. Then furlough, we thought we had heard the last of this during COVID. I know this was a very hot, buzzword during this, but really this is, a temporary reduction of working hours. So the key difference here is intent. So if it's performance, we're looking at a termination. If it's a business need, we're looking at a layoff or maybe a furlough in that. So again, from a furlough perspective, the employee is retaining their rights. So they might still need to be getting health insurance or benefits, depending on your policies there. But this is just reducing them working for you for a specified period of time. You don't always plan on having them have that reduction of work hours or weeks or whatever. Eventually that will come back to normal. So this is probably, again, pretty familiar from COVID times that we went through this a lot. But again, mixing these up can create serious problems later, which we're going to dive into. And so why should we care about this? HR compliance isn't just a nice to have. It incorporates the legal requirements and best practices that really aren't optional for you. I love to say compliance is caring about your team. Those things that make you be in compliance are typically how you have to treat your employees, what you have to offer to them, kind of your lines that you have to stay in to keep them employed and to really, have that be a seamless working environment. But a lot of these things, again, you don't have a choice around them. And a lot of people think that HR might strictly be payroll or recruiting or making employees happy, but there's a lot more that goes into that. The compliance piece is really important because courts are generally not that forgiving when it comes to lack of awareness of laws or compliance. So we can't really argue, I just didn't know, ignorance is bliss doesn't really apply when we're looking at a compliance angle of an HR issue. And the other part is that these HR compliance requirements are implemented at all different levels. So we have federal laws, we have our state laws, we even have local laws, and there's a lot we have to figure out of, well, which one wins, and really which one wins out of these different levels is whichever is the most favorable for the employee. And so again, it's not just about keeping the employees happy. That is a big part of it when you are caring about them enough to have all of these things in order. But just like you have malpractice insurance for your practice, it's really important to ensure that you have the right tools in place to keep your HR in order as well. So let's look at what are the most common claims. And when we talk about lawsuits, most of them fall into wrongful termination claims. So these typically include claims around discrimination, retaliation, pregnancy-related claims, and leave-related claims. So let's talk through some of these. So if we're looking at a protected class, it is illegal to fire somebody based on protected characteristics. Okay, so these characteristics include things like race, gender, age, disability, religion. So you might be aware of that, but just keeping in mind, it is absolutely illegal to fire anybody for these reasons. Then we have unsafe working conditions and reporting those. And ironically, I actually just saw an article about two former employees of a dental practice in Michigan, and they are claiming that they were fired after raising concerns about dangerous, unnecessary procedures and even like fraudulent billing. So some pretty big ticket items that they are saying that they raised these things to the dentist and the practice owner, and then eventually they were fired after they raised these things. And so these employees are seeking back pay. They're also seeking punitive and compensatory damages. And so this can add up to a lot. So you want to be really conscious of if employees are reporting things that might be unsafe or they're saying are illegal, and then you make an employment decision about them, it can be really, really risky. And then we have the instances of firing somebody for taking a protected leave of absence. So the types of protective leave vary by state, but it's not just about medical leave or pregnancy leave anymore. I think those were the things that we, focused on years ago. Now there have been so many different laws, depending on the state, that are bringing in many more protected leaves. Meaning, if somebody takes a leave for those reasons, if they exercise their right to be able to be out of the office for those things, and then you make an employment decision of parting ways with them, it can be seen as retaliating against them because they took that leave. So the numbers of leaves and the types of leaves do vary, but some for you to kind of resonate with are paid sick leave. That is considered a protected leave. If you're in a state that has a requirement for paid sick leave, they take that paid sick leave and then you let them go a week later, it could be perceived that you were retaliating against them because they took that sick leave. Also, we have states like California had this a couple years ago that passed. We're seeing it in other states, bereavement leave. You don't necessarily have to pay for them to be out on bereavement leave, but if they do take bereavement leave, you have to allow them to take that time and then do not want to part ways with them because of that. Jury duty is also a big one. That's every state mostly has some sort of requirements around jury duty. You can't tell them that they can't take their jury duty. You can't retaliate against them for showing up for that. And then also things like if they're a victim of domestic violence, there are states that are rolling out leave laws around those protections. So a big thing with the leaves is that first, you absolutely want to make sure that you have the most updated employee handbook that 2026 needs for you to have, because that's where most of these leave laws are stated in there, and then what they need to do if they have to take those leaves, which we'll dive into in a second. But really be aware of if your state has a leave, and then you want to also make sure some states, they love to make it complicated for us. It's also based on employee size. So you might have, 5 or more employees, you have to do this, 15 or more employees, you have to do something else, 25 or more, you have to do something else. So it's really important that those policies are in place and that you're following them and not, retaliating if they're taking those leaves and essentially terminating them. Of course, retaliation for reporting sexual harassment is a big one. That is the last thing that you want to do. Really, again, anything that they're reporting that is going wrong, even if it's not happening or you investigate it and you see something else, you find something else is the reality. You want to be really, really careful around those situations. And again, always pregnancy leave. We hear it so commonly that things might be going fine with an employee. We have them coming in. We might not love them, but they're doing good. And then they say, well, I'm pregnant. And then you feel stuck and you're like, well, I want to terminate them right away. We hear it all the time. And that's definitely a risky time to terminate somebody. We'll again dive into that a little bit more in a second. So just be aware, these are the claims that are common, that are happening. This is where we see where it's like, they fired me because of one of these reasons and they weren't allowed to fire me because of these things. And this is the key. Employees don't have to win these lawsuits for it to cost you money. Like, they just have to file them. And then now all of a sudden you're in this legal situation where you're paying lawyers and you're having to have all these meetings with them. It takes your focus away from the practice. And so we really want to be able to avoid these. That's our goal at HR for Health, is to avoid these issues from happening so that you are able to be productive throughout your day and not have to worry about these things. Okay, so let's really get into the meat of it. Why most of you are probably here. These are the most common mistakes that we see practices make. And they might be mistakes that you've made before. Maybe you've gotten by with doing it. But these are the things that almost always bubble up and create issues. So this is a very common misnomer, kind of similar to my at-will conspiracy, where you might think that because somebody is in their probationary period or introductory period, depending on what you call it, that they are fair game to fire whenever you want within that introductory period. So the most typical introductory period or probationary period that you see is 90 days. That can vary depending on what you decide. Because probationary periods are not a legal thing. Like, probationary periods are a made up timeline by people in human resources that is basically establishing kind of like a monitoring period for that employee. So a big misconception is that the probationary period is kind of your get out of jail free card, is that, well, they've only been with me for 3 weeks. It doesn't matter. And I'm at will. I can just fire them for any reason. And that's not the reality. Day one, that person is your employee as if they were on day 121. And so you have to treat them in the same way that you would as if somebody was not in their probationary period. So there is risk there of just trying to fall back on that. But then there's also the aspect of firing somebody too quickly without giving them a chance to improve. That can also increase your risk, because you want to be showing that you're making an effort to make this person work for your practice and work within the environment. And the other piece is, it's hard to find people right now. It is a time-consuming process to go through the hiring, go through the screening, the interviewing. And so we don't want to just like part ways with them immediately. So some tips I have for you here is, of course, train and coach your employee. First and foremost, you want to make sure every single employee has a job description. If you're an HR for Health client, that's automatically happening for you. We have all those job descriptions in there. Every single person gets a job description on day one. You want to set those expectations for them right from the get-go. You want to establish during this introductory period or probationary period check-ins with them. You want to do 30, 60, 90-day check-ins minimum. And this is really to give them feedback on what they're doing well, what they can improve on. And also it's giving them a chance to learn and improve. And if you're doing all of those things, you're kind of killing two birds with one stone, because one, you're investing to really see if that employee is going to work out and really giving it a chance to see where they fit into the practice. But then you're also doing the things that you need to do, that if you're going to part ways with them, it's much easier, much safer, because you have this documentation of these different check-ins. You're showing that you've made the effort to make this work with them. And also some kind of, you'll see these stats here. I want to explain what those look like. So in 2022, the agency received 73,485 new discrimination charges. So that represents an increase of almost 20% when we look at the previous year. They also handled more than 475,000 calls, which is an 18% increase from the previous year, and managed 32% more emails from the public than the previous year. So the issues that are getting reported are on the rise. We're seeing that year over year. Also, we're seeing that the average harassment lawsuit settlement is about $50,000. So again, this is absolutely on the rise. It doesn't necessarily mean that discrimination is on the rise. It could, but it could also mean that employees are just more aware of what their rights are and what their, used to experiencing, and they're now getting a little bit more savvy of how they're reporting these things. And it's not something that I don't think anybody is intentionally doing, but you could have somebody in the practice for 3 weeks and then all of a sudden this happens, because these claims are really rising. So definitely something important to pay attention to. Don't just use the probationary period as your get out of jail free card. Treat them as if they're any other employee. This one gets practices in trouble all the time because it's confusing. It varies per state. It varies if somebody quits versus if they resign. They quit versus if you terminate them. And the thing is, the final pay is really highly regulated. So the mistakes that go into this are just not paying a final paycheck on time. That's a big issue. Deducting things from their final paycheck, not paying out sick, vacation, PTO if it's required by your state. And then those things can result in penalties based on what, again, state you're living in, how long it's been since you gave them the right final paycheck. So a couple ways that you can address this. First, be aware of if somebody quits versus if you terminate them, that you are going to have to pay them quicker if it's a termination versus if it's a resignation. When you are looking at the deductions, we get this question all the time. They didn't give me my keys back. They are supposed to pay me back for uniform. They, have a laptop. And the biggest mistake you can make is deducting these things from their final paycheck. It is not worth the money. I promise you that you're even getting back to rekey the office. Because if you're going to deduct from an employee paycheck, you have to have authorization to do that. And that's very hard to get them to authorize at a final paycheck time. So the other thing that we see happen is withholding that final paycheck until you get items from the office back. You absolutely don't want to do that because those penalties do stack up. When we're looking at paying out vacation or PTO, this again varies per state, but if you're in a state that requires you to, if it considers vacation or PTO earned wages, then you do have to make sure that those are in the final paycheck. Then there are other states that say you don't have to do it, but if your employee handbook doesn't state that you're not going to pay it out, then you have to. You also have states that say if somebody resigns, you don't have to pay it out, but if you fire them, you do. So you just want to be really careful about knowing what your requirements are there. And again, if you're ever on the fence of should I put this in the final paycheck or not, I would always err on the side of caution, more is better. Also in the final paycheck, this is really your opportunity to make whole, to make sure the employee is paid for everything that they should have been. So making sure any overtime that's owed is in there, bonuses, everything from A to Z should be in that final paycheck. Other thing that you want to keep in mind is that if somebody is, especially if you're terminating somebody, be careful of paying them by direct deposit because they have authorized you to pay them direct deposit. And when you terminate them, you're essentially terminating that authorization for them. There are ways that and this might happen for resignations probably more commonly, if you want to pay them by direct deposit and they say, yeah, for sure, pay me by direct deposit, you need to get a separate direct deposit authorization form. So again, at that time where you part ways, whether it's because you are firing them or they're resigning, we are cutting off that authorization for direct deposit. So you do need to get a separate acknowledgement from that. If you don't get that, let's say somebody just isn't in the office, they don't ever come back, you want to make sure that you send that final paycheck certified mail so that you have proof that you sent it, it got there on time. So again, making sure that if you're owing them anything from overtime to that PTO to bonuses, that you are putting all of that into the final paycheck. And then ideally you're having the employee sign a final paycheck acknowledgement. So if you're an HR for Health client, you will know that as part of the offboarding checklist, there's that document in there, which actually breaks down, here's everything that's in your final paycheck. So here are your normal wages, the vacation. Again, if you have other things you're reimbursing them for, it breaks all of that down. And then they're signing saying, yep, this is, to my knowledge, everything that I'm owed, so that you have that documentation in there. So really, really important here. It is such an easy mistake to fall into. And if you have any questions on what is right, what you're supposed to do, please reach out to us. And also keep in mind, this is why it's so important to have your PTO, sick, vacation tracking properly, not on Excel sheets, not by hand. Again, if you're an HR for Health client, that's all in there for you, so that you make sure that everything that's owed in that final paycheck is included. And we actually have a type of payroll run that is final paycheck payroll run, and it will pull all those things in. It will tell you what you're supposed to do based on the state you're in. So definitely don't want to make that mistake and be reactive there. Okay, mistake number 3. So this is probably the biggest one. If you don't document it, it didn't happen. What you really want to avoid is, if a lawsuit happens, if any sort of claim happens, you don't want it to be he said, she said. You do not want it to be your word versus the employee, because most states and most courts are going to be favorable to the employee. It's just a fact. And so what you want here is written warnings, performance documentation, records of conversations, all of those things, because otherwise it's really hard for you to defend yourself when somebody brings this claim in. Everything should be documented in an employee file, so it's very easy for you to identify. And the other thing is, don't wait to document. We forget, we want to make sure, again, if you're not using HR for Health to document your violations, it's a really great part of the system that can help you to do that. But if you are using something outside of the system for whatever reason, you want to make sure that you have the date, the time, what you talked about, and just don't let too much time go by, because we forget, details become foggy, it can become subjective. And so that part is really important. Time is of the essence, with this. It's because what you want to be able to show is that you are consistently letting them become aware of what's going on, and that, again, you were trying to make that better. The other issue that we see, not even just failure to document, but it's almost the reverse, where there's a lot of documentation that's favorable to the employee. So it's saying, this employee's great, you're doing performance reviews and everything in there looks glowing, and then you terminate them. That is contradictory, to what an employee would expect. So you want to be really honest in your documentation. And the last piece on this, you want to be as objective as possible in this documentation. So when we were looking at the reasons for wrongful termination, you saw one of those things, one of the reasons that can come into play is for those protected classes. If you have an employee that's a little bit older, that is not keeping up or whatever, using words like slow in the documentation almost makes it look like that's why you're firing them, is because of their age. So just be really careful about what you put in there, and treat every employee the same. You want to document everything for everybody, even if it seems small. It's good to have that conversation, get it on paper, and then it doesn't become I'm ganging up on this one person. It's just a normal way that you're operating in the practice. And again, the upside of that is that everyone's held accountable to the same standards, and those performance for other people should increase. And if it doesn't for certain people, then you're in a much better position to be able to part ways with them. Over-reliance on at-will. So I already gave you a little teaser of, the at-will conspiracy. So again, this is an employer's ability to dismiss an employee for any reason without warning, as long as the reason is not illegal. Okay, so we can't fire them for a reason that's illegal, which we showed in one of the first slides. Here's what happens, is that you're likely not firing an employee for reasons that would fall under wrongful termination. I think that we all want the best for our teams. We're not malicious in that way. But what happens is that you might be firing them because they've been tardy 5 times in 2 weeks, or they continue to be on their cell phone in front of patients after you've told them time and time again. But if an employee files a claim for wrongful termination and you don't have documentation and proof that you actually fired them because of their attendance, that seemingly small issue that might be like, yeah, obviously they were late every day, that can actually amount to a really big dollar amount, because when a claim is filed, it's your responsibility to show proof that what they're claiming isn't the case. So again, employee could say, I was fired for X, fill in whatever in the blank there. I'm a woman, I'm older, I took sick leave, whatever it might be. And what you have to show is, no, we actually terminated them because of the Y reason, not X. And so without that documentation, without that proof, it just makes it much trickier. So again, when you're looking at the value of documentation, you don't necessarily need to look at it from, I'm just setting up this person to be able to get rid of them. It's just best practice for everybody. And then if you need to use it at the end of the day, you already have that ready to go and you can pull from it. This one is a subtle one, but it's definitely risky. So converting resignations into terminations. So how this happens is that somebody might come to you and say, okay, I'm resigning. I'm giving you my 2-week notice and I'm scheduled out for the next 2 weeks. I'll be here and then I'll see you later after 2 weeks. And then what happens is you go, well, actually, I wanted you to leave anyway. Thankfully, you quit. And so I'm just going to have you stop working tomorrow. What you've actually done is just turned that resignation into a termination, because they said, I'm going to work for 2 weeks. And you're saying, nope, I'm actually going to have you stop working tomorrow. And this has increased your risk exposure. So there's a couple ways that you can deal with this. One, you can be okay with the fact that you just turn this into a termination, and then you want to make sure you're following all the steps of the final paycheck requirements and all those things for a termination. Or another thing that you can do is say, okay, well, what I'm actually going to do is I'm just going to pay you out for those 2 weeks, but you don't actually have to come into the office. That can continue to keep it as a resignation because they're technically still employed for those 2 weeks. You're just saying you don't have to come into the office. You might be like, well, why would I pay them to do that? And that's ultimately up to you. I think it depends how risky this person is. Again, if you feel like it is just too much to have them continue to come into the office, they're going to be toxic, it's going to impact the other team members, it might be a good idea for you to just invest in saying, you know what, cool, I'm going to pay you out for the 2 weeks and then we're good to go there. If you don't see too many issues with just turning it into a termination, then, that's your option as well. So just get help on those decisions. We'll talk about that in a little bit, but you do have those options. The other thing that I want to mention that is kind of in play with this, that's almost on the reverse side, is slowly reducing somebody's hours or slowly reducing their pay or slowly reducing their job, like their responsibilities, in an effort to try to get them to quit, can also lead to a lot of issues. So again, if you need to do that for the business and you just don't have those hours to give them and you're not scheduling somebody else for those hours, that is a little less risky. But if you're trying to couch this as, well, I'm just going to subtly start to bring them down a notch and bring them down a notch and bring them down a notch, they could say that, you were trying to push them out of the job. So just be aware of that. This is an interactive thing when these situations come up, and the employee does kind of have a say in how this works, or if they're setting that precedent, then you want to make sure that you're aware of all right, I still got to pay you for 2 weeks if you're leaving, or, if there's a performance issue, I don't want to address that by reducing their hours necessarily, unless me and the employee agree on that. And that's something that they need. Again, not to say you can't reduce hours and you can't reduce pay. It's just something you want to get help with to make sure you're doing it correctly and that it doesn't appear on paper to look like you're just trying to push that employee out. Okay, dismissing a member of protected group. So this is definitely the riskiest situation, or these are the most riskiest situations that you could find yourself in. So when employees fall into those protected categories, primarily what we look at here is if they are pregnant, if they have a disability, or if they're old. based on age. What's crazy is that the law technically says anything over 40 years old is considered that. That's just wild. It's really closer to like 60, but depending on how close they are to 60, the risk kind of increases. But these categories really increase your risk almost automatically. It doesn't necessarily mean that you cannot terminate, but it does mean that you have to be really vigilant about how you handle these situations. So first and foremost, like, you want to make sure you have, again, those clear job descriptions. If somebody's asking you for accommodations, you're, accommodating those where you can. You have really strong documentation, and that you're working with somebody to help you. So again, that job description is outlining not just their job duties, but also the essential functions for that role. The essential functions is saying these things have to absolutely happen for somebody to be able to do this role. Like, it's essential for the role. And we can't put everything in the job description under the essential functions, but this is a section that can really help, because most of you probably know these laws come with some fine print that say you have to accommodate these things unless it creates undue hardship on the business. And so the essential functions section is identifying what would create undue hardship for your business. Again, it doesn't mean it's just like super clean, you can fire them because of that, but it is absolutely necessary for you to have in place to even be able to take that step. You also want to follow that interactive process. So the interactive process is going to help you to determine what you need to provide and how you provide it for these types of leaves. So that starts with the employee notifying you, okay, I am pregnant. I'm going to need to take a leave of absence. Here's my doctor's note saying what I need accommodated, when my leave is going to start, when I'm going to come back. You're documenting that. You're talking with them about, that's why it's called an interactive process. Everything should be documented. You're establishing, okay, this is when you're going to come back. If they don't have a date that they know when they're going to be able to come back, then you are going to continue to communicate with them as they get that. You want to continue to get doctor's notes. If the doctor's note says they need a certain accommodation or they can't come back, you definitely want to respect that. And, but you want all of this stuff documented. If then they continue to push their leave back, that's a different conversation. But so many people miss that step of just even starting on the interactive process. And it's not a bad thing to ask for a doctor's note. It's not a bad thing to ask for their plan. So make sure that you do that. It's going to save you so many headaches in the long run to do that. And then again, do not terminate or discipline an employee for taking that protected leave of absence or informing you about a disability or anything. And really, above all, for these situations, you really want to make sure that you are getting support from ideally an attorney. So if you're a client, you know this, if you've gone through it yourself, if you reach out to our HR team about a situation where, about the interactive process for, let's say, a pregnant employee, we'll walk you through that. But if you continue to push us and say, look, I really want to let go of this employee, we're escalating you to the law firm that we partner with to be able to get legal advice on how to handle that. So you absolutely do not want to handle these things by yourself. We also have a QR code here for you to be able to download, because there has been a lot of new regulations around, this is at the federal level, the Pregnant Workers Fairness Act. So this will give you some resources into that if you need it. If you're not aware of what those things are, feel free to scan it, and that will help give you some more background information there too. Okay, first I have to say, when we're looking at this slide, is that a termination should never come as a surprise to an employee, right? Like, if you're consistently holding them accountable and you're informing them about the issues and you're putting steps in place for them to improve, they should not be surprised when they're terminated after those things don't improve. And so that is, keep that in mind of kind of your internal gut check on how you're moving forward with things for your team, of if I fire this person, are they going to be completely blindsided? If the answer is yes, we probably need some more conversations and documentation in place to make sure it doesn't create more issues. The other thing is that when you are handling the termination, more communication is not always better. So when you're terminating somebody, you want to be clear, you want to be concise, you do not want to over explain. you want to remember that the more you say, the more opportunities there are for something to be misinterpreted or used against you. So some examples here: if you're terminating for poor performance, the reason you want to give is employee did not meet the performance expectations of the practice. If you're terminating for an outburst or aggressive behavior, the reason is employee misconduct. So even if there's all these like nuances, assuming that you've addressed those, you want to make it very concise at the time of termination so that they're not like parsing things and like, well, that's not actually how it happened or whatever. So just be really aware of how much you share and what you put in documentation on that final, termination letter, or however you're communicating it. And if you have questions on like what to include, what not to include, of course, again, reach out to us. We're happy to help with you. Here's a little bonus tip. I have to say, this is where I know people get really frustrated about our kind of stance on this of disputing an unemployment claim. So I know it really grinds your gears when an employee that quit files for unemployment, or somebody that is just obviously not eligible for unemployment files for unemployment. We highly suggest that you do not automatically dispute that unemployment. The reason being is that when you dispute the unemployment claim, it almost always riles the employee up, and they're like, okay, well, if I'm not getting unemployment, I'm going to figure out a different way to fund this for myself and fund my life. And so it is a huge indicator when that happens that an employee will file some sort of claim. The other thing is that your unemployment costs are really, they're like soft costs. They're already built into what you're paying. Again, unless you have crazy amounts of turnover and crazy amounts of people like going into your unemployment fund, you don't really see that much of a difference in terms of what you're paying. So just remember, like, I know that it can frustrate us when those things happen. We don't feel like that employee deserves it. But if an employee seems at all disgruntled and files unemployment, you can make them much more disgruntled if you're fighting that claim. And it's also very hard to win when you fight unemployment claims. I have heard stories of people doing it and it being fine, but unless it's something really egregious, like just keep that in mind to, reduce that risk, because that's what we want to do. Like, we want to keep these conversations civil. Everything's documented and objective. The terminations are fair. It's not personal. It's based on what the practice needs and trying to reduce your risk. Okay, so let's now look at the solution. So, what do you actually do now? So key takeaways here. First and foremost, create a process for documentation. This is not text messages. This isn't, something in your notes app. You want to have a clear structure of, here are the things that I'm documenting. This is the format for what I'm documenting. In the HR for Health system, you'll notice that it actually breaks out for you. What's the type of the violation? Is it informal? Is it private? Is it formal? And then we give that template of like, okay, what rule and what policy was violated? If you don't know, then it's probably not going to be a strong write-up. So we want to keep that as objective as possible. What happened? Who else was involved? What was the date of the violation? What are next steps on it? So everything should kind of be documented the same way. And then you make the decision of, is this just something private I'm going to keep in the employee file because it's maybe the first time it happens, not a huge deal? Is it going to be informal where they're aware of it, they see it, but I don't make them sign it? Or does it need to be formal where it actually sends to them for signature? The next thing to look at, if you're not sure, knowing your state's final pay laws for a termination and for a resignation. So knowing, when do I have to pay them? What has to be included in that final paycheck? Again, we have a lot of resources around that. If you're in a state like California, just assume you have to pay out everything and anything to them. But again, we're here to help if you're not sure what those things are. Understanding the final paperwork requirements. So again, if you terminate them versus they quit, there's different final paperwork that you're going to give them. And then this also varies by state. So make sure that you're aware of what the termination letter, the final paycheck acknowledgement, and then states actually have like required things you have to give out, like COBRA notifications, what happens to their 401k, all of those things. So just make sure that you understand what those requirements are and that you have all of that in one place. The other thing is that we recommend that you have 2 copies. So you have a hard copy for the employee, and then you have a copy for yourself of the employee signing all of those documents. If the employee doesn't sign the documents, like if they're hostile or whatever, that can create a lot of stress, I know, for yourself of like, okay, what do I do here? At the end of the day, like them signing it is an acknowledgement that things are correct. So we really want to get them to sign it. But if they're just like ignoring you, they're not answering your text, whatever, make sure that you're doing what you need to do to send stuff certified mail so you have proof that you provided it to them, so that you've done your end of what you need to do. Having an up-to-date employee handbook is such a big one here. All of this kind of stems on these next 2 of job descriptions and the employee handbook. This is where it starts. I know it might seem crazy of like, Jill, they know they're not allowed to be late, or they know that they have to come to work looking put together in their appearance, or they know that they have to know how to use Dentrix in the office. Like, but the big thing here is that, yes, you're right. You know, we as adults, we should all know this, but from an employment perspective, our responsibility is to give those clear expectations to our team members and tell them exactly what we expect and what's going to happen if they don't follow those things. And that's going to be outlined in your employee handbook for the office as a whole, and then in their individual job descriptions of, again, those expectations. So it might seem like the biggest nuance, or I'm sorry, the biggest nuisance of just, you know, oh my God, they're always talking about handbooks and job descriptions, but this is why. Like, these are the small things that add up that could really create an issue. Because if you don't have that handbook up to date, those leave policies are not up to date. So you're not sure what you're supposed to be following. They don't know how it works. Like, it just snowballs and can become such a bigger issue. If, you know, your handbook doesn't clearly lay out PTO, vacation, sick, then it can get very messy when you're trying to do those final paychecks of what's actually owed to them. If your policy doesn't state that you don't pay out vacation, and you're in a state where you're allowed to not pay out vacation if it's stated in your handbook, and you realize, oh my God, it doesn't even say anything in my handbook, and I have to pay them for no reason. Like, these are all the little nuances that really make a difference. And then last but not least, training your managers, if they are the ones dealing with the employees on the day-to-day perspective. If you have your office manager in there, maybe you are the office manager that's on this call, like making sure that you are trained on all these individual things. If the owner is, you know, putting you in charge of being responsible for that, you want to make sure that you're aware of how to do these things correctly. So again, this is about building a system for yourself, not reacting in the moment. We hear so many times when we talk with doctors or office managers that there have been issues that have been piling up for 6 months, a year, and then all of a sudden we hear about it at the time when termination comes into play. They're very concerned about patient lists and confidentiality, as anyone would be. But all of those expectations and all of those policies and the right and wrong and how data is handled, all those things are established when somebody's hired, not when they're fired. So you don't want to be reactive in this situation. Outside of an employee coming into the office intoxicated or doing something like really crazy, it should not be like a snap decision of if you fire somebody. Like, it should be you really working to try to figure out how to make it work. And if they don't, then you part ways. If you're not sure about where your risks are today, if you're looking at that image I just showed on the last slide of the different steps, you're not sure where to start, or maybe this opened up like even more of a can of worms for you of other things that might be going on from the HR perspective, or if you're just curious about kind of where you stand right now from your risk, we just built, this is brand new for you, that is a free HR risk assessment. So it takes about 5 minutes. Again, it's built specifically for you, and it's going to ask different questions for us to help to understand your risk. And then it's going to build a custom report for you about where your biggest risks are, what to do with those things, you know, kind of helping you to prioritize. Like, if there's a lot of stuff going on that you want to fix, we want to help you to figure out what you do when you do it. So that report is something that is included in that once you submit the risk assessment. So you can scan this QR code to be able to take that. And again, we want to give you those clear next steps so that we can tighten this thing up, because the reality is a termination risk is really usually just one piece of a bigger picture. Like if there's a lot of risk around termination, there's risk from a daily perspective that you might be able to get those things cleaned up very easily, but you're just not aware of where those gaps are, where those holes are. So that's why we created this tool. Please feel free to take the risk assessment. We're very excited about it to just help instill some knowledge in you of like whether you're a client or not. This helps you to understand at least where you're at right now to help fix it. And then again, our goal at HR for Health is to prevent you from having to deal with these pitfalls. Our entire reason for being is a proactive approach. And we can't make it where lawsuits never happen, but if they do, we also want to make them go away very easily because you have all the documentation, you've done all the proper steps to manage the HR compliance side. Because we hear stories across the spectrum, like from trends with employees consistently working overtime when you don't want them to, not coming into work, tardiness trends, all the way to the termination side of things, non-compliance, classification of employees, putting somebody as a 1099 when they should be a W-2 employee. Like we really see the gamut. And our goal is to really help you maintain compliance all the time and get in front of it. So if you're not familiar, we have our HR advising team, which I've talked about a lot today, of like how that's a big resource for you, where we help you on a case-by-case basis, depending on what situation has arisen, to make sure that you're protected. Because a lot of this all comes down to how you respond to the situation. So if an employee isn't meeting your performance expectations, as an example, like our team will walk you through how to use our software to properly document that. If you are, constantly feeling like people are late, our software tracks that for you in real time. So you don't even have to manually do documentation. It's just automatically pulling that for you. The employee handbook is a big thing. That's the first thing attorneys look for, is if you have an employee handbook, if it's updated, because an employee handbook is the most basic part about HR. And so attorneys go, well, if they don't have the most basic, standard part of HR, what else don't they have? And so that's where they start digging. And with laws constantly changing, a lot of our practices, they're wondering what requirements do I need to follow? How do I deal with these changes? And we're automatically updating that handbook as laws change. So we make it very easy for you to stay on top of that and have that as your first line of defense. And then the last one is wage and hour claims. We absolutely want to prevent those. We pull all of the electronic timekeeping and documentation from HR for Health to protect you against wage and hour claims. So whether that be about meal breaks, rest breaks, overtime, paying out bonuses, weighted average, if you have 2 rates of pay, we want to make sure that you are absolutely bulletproof with employees clocking in and out, making sure you're paying them what they're owed, timestamps, audit logs if things are changed, everything from A to Z, to make sure that your software is really helping to protect you and you can count on that information to be accurate and compliant. So again, we see these issues all the time. We really want to make sure that you're not paying a huge dollar amount that you don't need to be paying. So as we wrap up, again, one thing, if anything I want you to take away is most of these lawsuits do not come from bad intentions. You're not trying to do these things. It's just you don't realize some of all these pitfalls that can add up and create something really big. It's coming from inconsistent processes and lack of documentation, lack of the employee understanding where they stand and what they're entitled to, and you not being sure. So nobody's trying to do anything wrong, but we definitely want to fix those inconsistencies in processes, that lack of documentation, so that you're dramatically reducing your risk. So as we wrap up, I'm not sure if we have any questions. I know
we do have 2 questions, actually, Jill. Thank you so much. We'll start off with one from Sean, which are, what are the impacts of losing an employment claim or acquiescing to an unemployment claim?
Yeah, so essentially, if you lose an unemployment claim or somebody is basically awarded unemployment, there is a fund that you're paying into each payroll for your unemployment to have that coverage for you, and then it essentially draws from that. So when I say the dollar amounts do vary of if they could increase your premiums because of it, but it is very like negligible. It also is the shorter of the time the employee has been with you, the less you're on the hook for, because when they look at unemployment claims, they're looking at all of their employment history and like where else they worked and who else they're pulling from. So it's definitely small, and it's definitely not worth the trying to fight the employee on it.
Awesome. And then here's another one from Lauren. Is it worth offering a severance at termination in return
Mhm.
for signing a form to say they will not litigate against unfair dismissal? I've heard that big corporations do this.
Yes, amazing question. Yes. So we didn't talk about severance agreements, I realized. So first and foremost, yes, severance agreements can be a great tool, especially if the termination is risky. Look, if they are at all within a protected class, you always want to have a severance agreement in there. That is something a law firm does need to draft with you. It has to be a legal document. So please do not Google that. Don't ask Facebook, for that document. It does need to be a legitimate thing. Just keep in mind that the severance agreements don't protect you from things that are illegal. So like wage and hour claims, if you just didn't pay them their overtime correctly, like it's not going to protect you from that necessarily. So there are some like pitfalls, but yes, overall, unless somebody is extremely disgruntled, if you're paying them a severance amount, they are signing an agreement saying, okay, I will leave you alone basically in return for you paying me whatever amount it is. And again, that amount can vary. It depends on the risk. It depends how loud you think that this employee would be, and an attorney can help you to work through that. But yeah, that can be a really great strategy, and sometimes a necessary strategy depending on the situation.
And then another one from Lauren. Break penalties. We were lax about enforcing staff when they went on break time in California. We're much better on that now. But if we terminate an employee that was likely eligible for penalties from the past, should we
Mhm.
add a chunk of back pay to their final paycheck, or should we make a one-off back pay to all staff?
Whew, okay. Yeah, I feel like we should connect offline on some of these nuances, but I will get from generally speaking. So in California, it is not your responsibility if the employee actually takes their break. It's your responsibility to make sure they're offered a break. So if you're an HR for Health client, I'm not sure if you are or not, you'll notice that every time somebody clocks in, they get a banner that says, "Don't forget to take your rest break today. If you're not able to take it, let your manager know immediately." This helps to protect you, to make sure you're offering it every day, and that if they're unable to take it because of the way you've scheduled them or whatever factors from the practice, that they're alerting you so that you can make that right. If you're already aware of rest breaks that didn't happen because they weren't able to take them, yes, absolutely, you should include that 1 hour of premium pay for them for however many instances it happens into that final paycheck. Whether you want to go back and do that for all employees, that's the part I would like take offline, because we probably need more information from you about where everybody sits, like how large is it. But if those, like the time to get that right and get that paid out is in that final paycheck, that is a great time to do it.
And then one from Narla. What if you have a pregnant employee whose, quote, morning sickness becomes an all-day sickness? She's supposed to work 4 days a week and only works 1 or 2 days a week. Can this be undue hardship for the employer?
Yeah. So we'll reach out to you to get specifics on this one too, because again, it depends on your state, like size of the practice, how many employees, on some of your options there. Generally speaking, first step I would do is ask for a doctor's note for what's going on there, because that really should help to guide what has to happen next. And that's, again, a lot of the times just like, oh, you're pregnant. All right, it's going to happen. But then these nuances come into play. So if you haven't gotten a doctor's note, I would start there. Talk with the employee about what sort of accommodations that they need. I would not fire them right away, but we'll connect with you offline on some more of these nuances. But that's generally speaking where I would start.
Nice. Okay. I think that is all the questions for now, unless
Okay.
anybody had any others. Wait just 1 second. No, yeah, okay. Thank you
Awesome.
so much, Jill.
Thank you, everybody, and be on the lookout for our law updates webinar. Mid-year laws are coming into play. Can't believe it's already almost that time. So some of this stuff around what you're able to do or not do might change. So be on the lookout for that. But thank you, everybody, and look forward to connecting with you soon.
Awesome. Thank you, everyone. Bye.